and I'm so glad you're here with me today. Thank you for joining. My name is Michelle Reese Johnson with AmeriEstate Legal Plan, and I will be your host today. If you are on this webinar, you were invited by somebody who cared enough to invite you and who wanted to make sure that you understood the importance of estate planning and a living trust. So that's why we are going to dig right in to living trusts, estate planning, and help get you some important information that will probably be very enlightening for you, because I'm going to share a few things about just the mechanics of estate planning and what happens in probate as well. I always find it very interesting that the things I learn daily about how probate works and the trials that people go through when they have to go through probate. So a little housekeeping, feel free to use the chat if you have questions, and after the presentation I will get to those questions. And this presentation will also be emailed to you after we're finished, probably the next day, I think, is usually when Caroline does that. So thank you for joining me, and I hope that this helps you think about setting up your estate plan if you haven't, and maybe you can get it done before the end of the holiday or just get it started, because we are having a special offer on that. And I'll share that with you at the end of the presentation. So let's get going. And this is just the basics of why estate planning is critical and crucial for most people who live here in the United States. It's across every state. Every people who live in each state need some sort of estate plan. So let's get going, and thanks again for joining me. So first question, if anybody can put in the chat, I always like to know my audience a little bit, and I ask these questions. Do any of you have any legal documents in place, such as a power of attorney for financial and assets, a healthcare directive, or a power of attorney for healthcare? Maybe you just have a will or a living trust. Does anybody here in this group have any of these legal documents in place at all? I'm going to get to the chat and see if anybody has joined in and made any comments. Yep, I have one person. Yes. Dory does not. We have a no. Not yet. Thanks, Nick. Thanks, Laquette. And Caroline says she does, but she has family that needs a trust. That's usually the case. Some of us have our estate plan done, but a lot of our families don't, our family members. So I hopefully can give you some tips and tricks and tools to talk to others about setting up their estate plans if you already have yours, or just help you understand why you should get one, and then you can spread the word. It's all about us influencing others these days, right? That's the big word now. So I want to make sure that you guys understand the difference between just having a will and a trust. Some people don't need a living trust, but we're going to talk about that as we go along in our presentation. And I'm expecting this to be about 45 minutes. It could go longer because I can get wordy sometimes. So just bear with me, because I go off on tangents, and I'll try not to do that because I just always find this subject so interesting. So let's talk about what are the most common estate planning strategies. Well, here are the 4 main ones. The first one is do nothing. The second one is a simple will. The third one is let's just throw people on title to our stuff because we don't know any other way. And the last one is a living trust. That's really about the 4 only ways you can do it in estate plan. Do nothing. And the best one is a living trust for most people. Not everybody, but most. Let's talk about what happens in the do nothing. I think we already know that answer. We just don't do anything. We have nothing in place. We've been adults. We've been adults since we were 18, And now a lot of us are up there in the years, and a lot of people do not even have a power of attorney. You've gotten along in life pretty well so far, right? Maybe nothing has happened to you. You haven't needed to use these documents, but um, most people don't even have anything because they don't think about it, because life just goes on and we're busy. The next most popular is just getting a simple will. A lot of people think, I got my will in place, I'm good. Okay, I feel responsible, I'm an adult, I have a family, I have children, I have the will in place in case I die. At least I'm telling the courts who's going to get my stuff and who will be the guardians of my children. Because let me tell you, a will is only good when you pass away. It tells the courts who's going to get your assets. It handles any guardianship, the people that you choose to be the guardians of your children. And it also, you can put beneficiaries in there. That's about it. That's about all a will does for you. It has nothing to do with while you're alive. So a will is probably, I tell people, at least you have something. At least you have a will, you've done something, because um, at least when your estate goes to probate, the courts will know what your wishes were and who's going to get your stuff and who you chose to be guardians. But I find most people who did wills have done them a long, long, long time ago. Maybe they did them when the kids were born, and then they just left it alone, and the kids are grown, and you've bought some property and have, opened a business or whatever. Life's gone on. So a will isn't going to be good enough for most people now. And things have changed for you. The other thing we see a lot is people adding others to title to their assets. We see oftentimes mom and dad think that, oh my gosh, what if something happens to us? We're going away on a trip. Let's just add our kids to title to our property. So they'll go somewhere and say, can you do a deed for me and put all my kids on title? Or they will do it themselves, get it notarized and record it. So guess what? Everybody owns a house with mom and dad now. And guess what? Maybe mom and dad want to sell the house. Well, everybody's got to approve that, because everyone's in and around that house now. Also, mom and dad might want to refinance. Well, guess what? Everybody's got to be involved in that refinance. Or maybe one of the kids got in trouble. They're going through a divorce. They got in a car accident. They owe some child support. If they're on title to assets, not just property, but bank accounts, we see that a lot. The parents put the kids on bank accounts, then those accounts are open for others. If you get in a lawsuit, that's open game for anybody to come in and say, I'm going to take that money out of your bank account. You own property. We're going to put a lien on that property because your name's on it. So be very careful about just putting others on title to your assets. Most people who are here on this webinar have assets. They have families. They have businesses. We've been here on this earth working very hard to accumulate our stuff, right? So when you have certain types of assets and situations going on, a living trust is going to be a better document for you and more protection while you're, not just while you're gone, but while you're living. Let's talk about an estate plan. What is an estate plan? Well, an estate plan determines what happens to a person's assets after their death, eliminating the need for probate. You might think that it can be determined with a will, but a will does not avoid probate. A proper estate plan does the following. It avoids, well, number one, it avoids probate. It also has your powers of attorney in there for health and finance. So with an estate plan, a proper estate plan, you're going to have your living trust. You're going to have also a last will and testament. You're going to have powers of attorney for health and powers of attorney for finance. So in case something happens to you while you are alive, you get in a car accident, Maybe you have early onset Alzheimer's. Maybe it's just you go into the hospital and something happens and you don't have these documents in place. It's going to be too late to set them up because you're incapacitated now. And the estate plan is also going to make sure that everything stays out of the courts, avoids probate, the costs and the time that occurs when you do not have a living trust. So let's talk about who needs a living trust. Well, anybody who's a homeowner across the country. Now, in California, our properties are pretty expensive, right? We all know that. So basically, you need to have a living trust for that property. And I would say most states now, prices are up everywhere. If you own property in other states, not just the state you live in, if you do not have that property in a revocable living trust and you pass away, you're going to have to go through probate in each of those states. All right, business owners, if you have a business, those also are subject to probate and problems if you do not have that attached into a living trust, meaning assigned. If you have children, minor children under 18, or special needs children or special needs adults, a living trust is super important for the parents to set up because minor children cannot get money when you pass away. And if you are a special needs person, if your child is special needs and they are on public benefits, that could cancel their public benefits if they come into money. So you got to make sure that you have a living trust in place that has special needs provisions that provide for those special needs children and holds the money in trust for them so it does not cancel their benefits that they're already receiving. Even single people, you don't have to be married. You can be single and have assets, right? A lot of people are single and own homes and have investments and toys and things like that, motor homes, boats, planes, things like that. All of those assets can go to probate if they're within in a certain limit. Like in California, it's about $204,000 of total assets. If they are not in a living trust when you die, it will go through probate in that state. Let's see. You have investment properties. You have land. You have stocks and bonds and things like that. If you do not have those titled into a living trust or a beneficiary on those things, they will go through that probate process. And also within an estate plan or a proper estate plan, a living trust, well, AmeriEstate's estate plan always adds the powers of attorney for health and asset management, because if you become incapacitated and you do not have those two important documents, nobody can act on your behalf, make decisions for you because you're still alive, but you don't have the documents in place. So what happens in that situation? A conservatorship has to happen, meaning you got to go hire an attorney, get approved by the court. It's about $5,000 just to get a conservatorship over a person who's now incapacitated. So you want to stay away from that altogether. So let's talk about some other reasons to avoid probate. One of the biggest reason is it takes a long time. What that means is your assets are frozen when you pass away. The courts are very, very backed up right now. So just to get a court date right now is about 6 months. Could be a little less. It just depends on what's going on in the courts. So you're looking at your assets, your bank accounts, your properties, your businesses, anything that has to do with if you don't have a beneficiary on them are frozen. Nobody can get access to your assets to handle things like pay the bills, pay the mortgage, pay the gardener. So that's what probate's about. It's like jail. Your assets are just frozen. Okay. So they can't be distributed. They're just sitting there and the courts are in charge. The attorneys are in charge, and it costs a lot of money. It's about 6 to 8% of the gross value of your estate to get those assets through this process. So without a living trust, this is going to happen to your estate should you pass away. 6 to 8% is on the gross value as well. It's not just on your house, less the loan on your house, like the net. It's based on the value of your $5 million home plus bank accounts, plus cars, plus boats, plus planes. So everything, let's say you're, up there 10 million gross, but maybe you have pulled out a lot of money out of your house and you have a loan on it. Well, it's going to be based on the gross value. So basically, your heirs are going to have to pay that money to the courts after everything is settled. That comes right off the top. So there's a little slide I have here that talks about the cost and how they figure it out. I think it's the next one. Also, you want to make sure that your kids are taken care of and you have your guardians set up properly. Now, the guardians are set up via the will. There is a pour-over will with a living trust attached right there. So that's where the guardians are named. And so you want to make sure that you have that in place because the courts are going to decide who's going to take care of your kids if you don't have it written down, because once you're gone, you can't tell others who you want your kids to go to. Another thing is I pulled this out of the paper today, not today, but I've had this. This is the back of the sports section. Let me see if I can show this to you. Let's see here, right here. Okay, so this is the paper, and you'll see if you look in the back of some certain sections of your local paper, it says, notice a petition to administer estate of Michael Gregory Honeyman. And it goes into this long paragraph about, hey, if you're interested in knowing about this guy's estate, here's the information where you can contact the court, get a whole list of what he has, find out what his assets are. Or if you're a creditor, you're entitled to see everything in this estate. So when you do not have a living trust, this is what's going to happen. It's going to be advertised in the paper, it's going to be online, and anybody can get access to what is in your estate. So you want to keep your affairs private because you don't want others coming after your stuff that have no business in your affairs. So if you have a living trust, it's a private document. It does not get advertised in the paper, like this paper right here. It does not get advertised. Nobody knows what you have because it's a private document. It does not get recorded. A lot of people think now that I have my living trust, it probably gets recorded at the county, right? I'm like, no, it's private. But if you don't have a living trust and you pass away, oh yeah, your affairs get to be public and anybody can snoop around. So you want to keep that private, right? So here's that calculator I was telling you about. Your market value, let's just 500,000. That's total. That's your house and some bank accounts, let's say. Look at this, $30,000. $30,000 just to get your estate through probate. And here's another calculator right here. It kind of goes into a little more detail, like let's add it up. This one says, it's hard for me to see it because it's so low, but your home, $700,000 home, a $280,000 brokerage account, a $200,000 investment account. You've got some personal property of $20,000, household furnishings. All this gets added up, and then you take the percentage. Everything is about $1,182,000. You're looking at almost $100,000. That could go straight to your children, your beneficiaries, your charities. But no, it's got to come right off the top and go to pay the attorneys, the judges, the processors, the court fees, all the stuff that goes on. And it's public information. So people come out of the woodwork when you have to go through probate, and they'll go to court and they'll sit there and listen to what's in that estate, and they'll go, hey, I was the neighbor. He promised me I could have this and that and blah, blah, blah. And you're not there anymore to say, oh no, I don't even like that guy. So you just want to make sure you stay out of this probate situation altogether. Now, I did tell you that a living trust is not for everybody, right? If you do not have certain assets or minor children or special needs children. Maybe you're just a single person, or maybe you're divorced, or maybe you don't have real estate anymore. And maybe you just have some IRAs and 401ks and you have beneficiaries on that. Well, there's nothing that's going to go through probate because you have beneficiaries on those accounts and you don't have real estate. So an estate plan or a living trust might not be for people in this situation. We do have that. People don't, not everybody owns property. Not everybody has $200,000 in brokerage accounts and this and that, or minor children or special needs children or businesses. So maybe a living trust is not going to be the perfect fit for that person. But if you have any of these assets, then a living trust is going to be a much better legal document for you to have to protect your assets. So let's do a little bit of comparison. Probate can be expensive, time-consuming, traumatic, and public. I see this all the time. We just had somebody who passed away without an estate plan, and I got a call from an agent whose brother passed away, one of our business partners in the state of Idaho, and he's like, my brother passed away without a will, and how I need to get information about his estate. And I said, well, it's public knowledge. Call the courts up and find out what he had. So he's going to snoop around and find out what brother had, and because it's public. So he's got to fight that fight right now, and that estate's going to have to go through probate because he owned homes and this and that. So a living trust, all these things can be prevented by setting up a revocable living trust. You're going to avoid probate altogether. You can settle an estate very quickly, or your heirs can, your loved ones, your children, your successor trustee, whoever's going to be settling that, as long as I have a death certificate. And there's a few things, especially in California, you have to do some probate letters, and there's some time issues in the beginning. But after 90 days, if everything's in the trust, then as long as you have a death certificate, you can get access to all the money. You can sell the property, you can transfer the property, you can settle the estate very quickly. So just know that you want to stay out of that mess of being locked down for 2 years in probate. And also the fact that the successor trustee, the person who's going to manage the trust when you're gone, if they have a death certificate, they can walk into the bank with a copy of the trust, their ID, and a trust certification that usually AmeriEstate provides to a successor trustee. We step them up. They can go right in that bank and get right on that bank account as a manager or a trustee. Because you will find that if somebody passes and you go into the bank, you say, my mom passed, so I need to be able to get access to her bank account. The banks will go, sorry, I need a death certificate. I need a trust. Who are you? They'll lock you out and they'll shut that bank account down the minute they find out that that person has died. So then all of a sudden there's no money available to pay bills. So you just want to stay out of that altogether. So, and also really important, get your documents set up in case you fall and hit your head, get in a car accident. We just had that happen to a client, a possible client. He got in a bad car accident October 28th. His wife is not doing well either. They're both in their 60s, and she's got kind of early stages Alzheimer's, and they don't have any documents in place. And they're like, oh my gosh, what are we going to do? The guy just came out of a coma, and they have to go through conservatorship. So we can't do anything for them at this moment because they're not capable of doing anything. So you need to make sure you set up an estate plan while you can, when you're feeling good, before something happens, because once that one thing happens, that's when everything gets locked down and nobody can assist. I wanted to touch on the do-it-yourself platforms. We see a lot of that going on right now, which I don't think is such a bad thing in a way, because it's getting the word out there that estate planning is important. But the thing is, these do-it-yourself companies are just document preparers. They got a lot of money behind them that they're doing lots of advertising. Like, I feel great now. I just got my estate plan done. Yay! I went online. It took me 10 minutes, and I'm good now. And they're thinking, okay, great, yay! I feel great. But let me tell you, the do-it-yourself situation is a doom it yourself. It's not a good idea for most of us just to decide how we're going to do our estate plan. We need to have proper counseling. We need to know what the red flags are. We don't know these things if we don't have an attorney involved to help us figure out what the proper path is for us. So doing it yourself is a really, really risky situation. And all these companies are doing is they want you to go online, fill out your information, and print your own documents, get them notarized on your own, get your deeds notarized, get it signed properly, get it witnessed properly. That's up to you. And most people have not done this or ever done this and know what the heck they're doing, but they have big disclaimers in there. I'm going to read that one of them to you. I put it in here about the disclaimer that every single do-it-yourself document platform or a non-attorney person will put right into their website or right on their documents. Let's see, right here, disclaimer. This is the disclaimer you're going to see on all these things that says, we are not a law firm or lawyers. We can help you with legal documents per your instructions. A legal document assistant is authorized to prepare legal documents for people representing themselves in legal matters. That's it. They're doing what you tell them to do, or you're telling that system what you want. But you probably have no idea kind of some of the red flags that go on. We see it every day. People transferring title to their property the wrong way, getting reassessed on property taxes, putting others on title that they don't realize, making a minor children or a special needs child a beneficiary. They don't understand the ramifications of that. So there's so much more to it than going online, filling out a form, and then printing it, and then you got to get it signed and notarized. There's very specific rules for each state, how to witness documents, proper notary, how to put assets into your trust, how to fund assets into your trust, like your real estate, your bank accounts, what goes into a trust, what does not go into a trust. You're on your own, guys. So you don't know it because nothing has changed in your life other than feeling good about setting up your do-it-yourself. But when the time comes and something happens, that estate plan is probably going to fail. So just be aware of the red flags of doing it yourself. Plus, these are all very cookie cutter. They're not specific to you. All of them have a very cookie cutter basic language. A lot of families are more complicated than that. AmeriEstate has different styles of trust to reflect the family situation. Not everybody has, me and Bob and 2 kids and a dog. We've got yours, mine, and ours. We have special needs. We have kids that shouldn't get money at a certain age. We have to make sure that we're getting the right counseling and not just using a cookie cutter document that takes you 15 minutes and you feel great about yourself. It's not a good plan. And frankly, we get a lot of people that call us and say, we did this do it yourself and we want to do it right, because they weren't feeling right about it. They knew that they were like, we did this, but we really didn't know what we were doing. So I just highly recommend, like I said, I think it's great. The word is out there. A lot of people are talking about estate planning. This is really good news, but just make sure you're staying away from non-attorney backed, non-attorney consultations, and with a company that's going to assist you with funding your assets properly into your trust. A lot of people have this false sense of security because they think that it's done. But oftentimes it's very incomplete, not signed properly, not witnessed properly, not notarized properly, and or not done at all. I see a lot of these plans where I get I said, send me a copy of the trust that you did on your own. And they said, well, I got it in the mail, but I never signed it because I was worried. Because you need guidance. That's the big thing. That's what we're here for, to guide you. So also, there's a hidden price tag in those do-it-yourselfs. They get you in the door, right? $99. Something's wrong when it's that cheap, right? And then they just start tacking on, do you want to do this? Do you want to do that? How about this? How about that? Before you know it, you're already paying more than you started with, where you should have just maybe thought about going to like an AmeriEstate Legal Plan, who is not a high-priced lawyer, but still has an attorney involved in a conversation with you. You are talking to the attorney, and you have professionals who are helping assisting to make sure your documents are signed, witnessed, notarized, and funded properly. So just be aware, there's lots of hidden costs in those. Let's get started. It's like a lost leader. So with AmeriEstate, I'm going to see if I can show you a picture of a trust with this Zoom. It's kind of hard to see, but you can kind of see. Let's see. Well, you saw it a little bit there. Now it's not working. But our documents are in this nice binder. It's about 2 inches thick. It's got everything, absolutely everything in here that you need. Your living trust, your pour over wills, your financial powers of attorney, your healthcare directives, your property deeds done right and notarized across the country. We can do the deed work in most states. And we also make sure that you are understanding how to fund your financial accounts into your trust. We have videos. We have our customer service line. You can call and ask questions. We don't ever charge you by the hour. You always just give us a call on the 800 number, and we're here to help. So we don't want you to be afraid, like even after you get your trust done, that you don't have a place to call without getting billed $500 an hour. That's not how AmeriEstate is set up. And I want to talk to you a little bit more about the legal plan that is AmeriEstate Legal Plan right here. So AmeriEstate Legal Plan has been around since 1998, and we've been serving California, Arizona, Texas, Tennessee, Virginia, and Maryland. I know we're kind of all over the place. It just seems to be our states that we have a lot of interested people, and we have some good volume in there. Our trusts are so much more affordable, and we've been doing this for so long. We have about 50,000 clients now that we have set up their estate plans for, and we're helping their kids now. Maybe they've passed away. The kids have called us, and now they're getting their estate plan set up after we coach them on how to settle mom and dad's estate. And everyone is just like, thank God they did this, because they avoided that probate mess altogether, and they were able to get access to their parents' assets very fast. And it's a beautiful thing. And so they give us a call and say, we want to do the same with you, because our parents did it for us. So it's just evergreen, right? Evergreen. So with the legal plan, AmeriEstate Legal Plan, you join our legal plan, which is included in the price. And what that means to you is you're a member, whether you like it or not, but it's a good thing really, because it helps you keep your trust updated. We also have access to attorneys for other matters across the state. If you need an attorney, we're going to get you a free attorney consultation and a 25% discount off their hourly rate if you need to hire them. So they're all pre-screened, they've been vetted, they're in good standing, and it's across the country. So it doesn't matter where your issue is. As part of the membership in the legal plan, we're going to get you the help you need for attorney consultation and nice discounts. We also have what's called a DocuBank service, which houses your power of attorney for healthcare online, and it's accessible 24/7 worldwide. So if you're off traveling, you slip and fall, you hit your head, you end up in the hospital down in Mexico or wherever you are, you will always have your healthcare directive on you, which will house if you're allergic to anything, who to call if you can't talk on your behalf. AmeriEstate's phone number's there. We can help them get in touch with your loved ones. So it's a nice thing to keep and have because so many people are traveling the world now or in retiring, and it's nice to have that healthcare directive on you at all times. And also, we encourage you to stay in the legal plan. It's $150 a year. It's optional, but a lot of people want to remain in the legal plan. That gives you access to changes and amendments to your trust, yearly reviews of your trust, like what have you done this year? Did you buy? Did you sell? Did you refinance? Did you have grandchildren? Do you want to change your successor trustees? You know, that stuff adds up. If you're, but part of the AmeriEstate Legal Plan is we keep the costs down for our clients to maintain their documents. It's kind of like having a maintenance plan on your car. It's your maintenance plan on your AmeriEstate Legal Plan. So just know that's there for you to keep active. If you don't want to, you don't have to, but a lot of our clients like to have that in their back pocket. Let's see, what else can we talk about? Oh, how about the cost of an estate plan? Well, does AmeriEstate cost 30 to 40% less than typical attorney fees? Yes, we do. Now, this year, well, the rest of December, by the way, we're offering a special discount for anybody who at least gets it started. You don't have to finish it, but gets it started by December 23rd, I think the 23rd, or maybe, no, it's through the end of the year, whenever the last day of the month is. That lands on, if it's Friday the 30th, I'm not sure. But anyways, that's available to you. But let me tell you, most attorneys charge about $3,000 to $5,000 or more to set up an estate plan like AmeriEstate's because, you know, they charge by the hour. That's how they work. And so you figure it takes them 10 hours to do a trust. So about $300 to $500 an hour. I think it's typically like $400 to $500 or $700 an hour now for people, for attorneys, what they charge. So we charge 30 to 40% less than attorneys do, but we still have an attorney involved. And the way we do it is we do it in kind of we have like a team effort. So when you call us or work with your advisors, we're going to take that fact finder information and get it all prettied up for the attorney. So when they call you, you're going to have everything thought out. And we're taking that busy time away from the attorney so he doesn't have to charge you that hourly fee. We're going to have it all worked out and prettied up, and you're going to think through your processes with us, and then he's going to confirm with you if that's a good plan, a bad plan, or change the plan. So he's going to back your trust. He's going to confirm that you are capable of doing this. He's going to stand behind that trust, and he's going to be the one, if anything goes down about that trust, he'll be the one there to pick up the pieces and make sure that everything that he's going to back you in your wishes on your trust. So this is what you're going to expect to pay. And with AmeriEstate, we are 30 to 40% less. So give us a call, and everybody's price is going to be a little different because it depends on how many properties you have, if you have any businesses, things like that. But still, it's very, very affordable for most people, and we can get you started over the phone. You don't have to come in and see us unless if you're near our office, you're welcome to. We're in Costa Mesa, but our most of our estate plans are done over the phone, and the attorneys also will speak to you over the phone or via Zoom as well. Just let us know. So with this end of the year promotion, if you get started, there it is, December 31st. If you get started, give us a call. If you want to get a free consultation, and if you decide you don't want to do it, but at least give us a call so we can set up a time to talk to you and let you know what the price would be based on your situation. You're still going to find it's going to be very affordable and a lot better than going directly to an attorney and sitting in their big leather chairs. So take advantage of that for sure. And then also a little bit more about us, of what we do here at AmeriEstate. We don't just do living trust, which is the standard, or basically I call the living trust the foundation for you. So at least get your living trust portfolio done. And then from there, if you need to, if you would like us to set up in a business, maybe you have some rental properties and things that you want to carve out into an LLC, we can do that for you. Once you set your trust up, if something happens to you, we can help with some incapacity planning to get the documents locked down for your health care and finance so others can step up and manage your affairs while you're alive, but you can't. That's called incapacity planning. And also, when you pass away, we're going to be here for your children or successor trustees and coach them as part of the legal plan. So know that that's available. And here's a little bit information on how to contact us. 800-235-0963. And here's AmeriEstate.com. Always put that I in there, AmeriEstate.com. If you want to learn more about us, check us out, go to our website, Facebook, Instagram, all that. We're online. You can see our reviews and everything. So let's see. Yes, you're going to receive your replay, Kristen. Let's see. Acelio says she has a trust. She's always getting calls about it, trying to learn more and hoping to connect for referrals. Perfect. Yeah. So we're here to help you, and we're here to help your clients if you're a business partner with us. But most of you who are here were referred by possibly one of our business partners, or they just want to make sure that you're fully informed and aware of an estate plan and what it can do for you and why it's important. And that's what I'm here today, is to help educate you. This is education and also a little promotion to help you get this started, hopefully before the end of the year. And if it doesn't work out, let us know at the beginning of the year and we'll be here for you then too. Does anybody have any other questions? I think we're about 45 minutes. Well, I hope I've helped you understand a little bit about estate planning and who needs one and who doesn't. Everybody needs an estate plan, whether it be just powers of attorney, if you're maybe 18 and young and you don't have any assets, family, kids, or anything like that. But once you get married and you have children, then you need to have something more, let's see, what's the word I want? Something that is going to make sure that your kids are taken care of. You've got to have it in writing and legally signed the right way. And if you start buying houses, you need to have that wrapped up in a living trust, because houses are the first thing to go through that ugly probate process. So, all I'm saying is, as long as you're an adult, get something going. No, you need to get powers of attorney done first. And then when you start having babies, buying houses, get a living trust. Just skip the will altogether. You don't need it. It's a waste of money. You need a living trust. That's it. Okay. So thanks for joining me. I hope you guys have a wonderful holiday season, and hopefully some of you have shopped. I'm going to get that going this weekend and get things decorated. I already started with my Zoom here. So enjoy your day, and we'll be hopefully catching up soon. Thank you, everybody. Have a good one.